you read a land title survey and you look at the list of exceptions to title insurance coverage that the surveyor shows on his map, the surveyor may identify some of those exceptions as non-survey matters, or she may use some similar language to that. So what does that mean? What makes an exception a survey matter, or conversely a non-survey matter? And what, if anything, should a land surveyor do with exceptions to title insurance coverage that are non-survey matters on a land title survey? Before we answer those questions, let's just briefly review what is a land title survey. So land title survey is a special type of survey that is needed to remove the survey exception from title insurance coverage. Okay, so if you're buying a piece of property and your lender usually says we would like to have you remove the survey exception to title insurance coverage, then the title insurance company is going to most likely tell you that's fine. We will remove the survey exception from coverage, but you have to go get us a land title survey. So it's usually required by the lender, and the surveyor needs to meet a specific set of requirements that are spelled out in a specification whenever she does a land title survey. So what is an exception to land title insurance coverage? Well, land title insurance, it's unique in many ways, but one of the things it has in common with other types of insurance is it has exclusions. So the title insurance company says, we're willing to insure the land title on this particular piece of real estate with this list of exceptions. In other words, we're not going to cover claims that fall into this group of exceptions. And there are exceptions on every title insurance policy. So it's really important for the lender to understand what's covered and what's not covered, because frequently the value of the property itself is going to be collateral on the loan that's being used to purchase the property, and the bank wants to make sure they're not going to get stuck with a borrower that defaults on the loan, and then they have a piece of property, there's some kind of boundary or title problem, and they can't sell it for what's owed on the loan. So they're very interested in making sure that if there is a boundary or title problem, that it's going to be covered under the title insurance. So let's think about a couple examples of some things that are common examples of exceptions that you'll find in a commercial title insurance policy, and I'm going to give you two. Okay, one is matters that would be revealed by a proper boundary survey. That is almost always an exception in commercial policies unless it's removed. And basically what that means is if you'd have gotten a survey before you bought and the survey would have revealed the problem, you can't come back later if you didn't get a survey and make a claim against the title company for that. And that's a pretty what we call a broad exception. So that would cover a lot of different things. Another example you'll often find in policies is that title insurance will exclude from coverage anything that would be revealed by any documents that would encumber the property that aren't recorded in the public records. In other words, they're not on file at the clerk and recorder. So if you've got an unrecorded deed that's up in grandma's attic in a chest, the title insurance company's not going to cover that if grandma didn't have her deed recorded down at the clerk and recorder. So why do land surveyors even worry about exceptions to title insurance coverage? Why do I have to care when I'm doing a land title survey? Well, I have to care because the spec tells me that I have to care. So the specification specifically says that land surveyors are required, as part of the spec, to map easements and leases and other encumbrances. So if there's an exception to title insurance coverage for an easement or a lease or a similar type of encumbrance on a property, and I can map it, I can put it on the ground, reasonably put it on the ground, then the spec says I have to do that. The spec also tells me that if there is an easement or a lease and I can't put it on the ground because of it's got a poor quality land description, then I also have to state that specifically on the face of my survey, that I can't map the easement and why I can't map it. So why do surveyors care about the exceptions to title insurance coverage? Because the spec says we have to care. We have to look at that list of exceptions, and if there's items in that exception list that can be mapped and put on the ground, the spec requires that we do that. So anytime we're doing a land title survey, A land surveyor like myself is closely inspecting each one of the exceptions to title insurance coverage. So, I don't want to go into detail about what the specification requires of land surveyors as it relates to easements. I'd like to do that in another video. This video isn't primarily for surveyors. I'll do a video more geared towards land surveyors that goes in and looks at the spec and the actual language in the spec as it relates to easements, because I think it would be good to do that. But for the purposes of this video, just know that the spec says I have to look at those exceptions, and depending on the circumstances, I have to map them if I'm able to do that. So, what makes an exception a, air quotes here, survey matter? You'll hear that term. In other words, when is an exception in the policy, the title insurance policy, something that I have to map? That's what, when we say it is a survey matter, that's what we mean. What we mean is it's an exception that I need to map and show on my survey. When we say something is not a survey matter, in air quotes, that means that the exception is not something that can be mapped and shown on the ground. Okay? So, what makes an exception a survey matter? A lot of times I will go back and forth with the lender or the title company or the lawyers. They'll say, this is a survey matter, you need to show it, and I might say, no, it's not, right? There's some back and forth. So how do you decide? I've got a couple simple rules that you can use, okay? Number one, does the document have a land description? If it has a land description, a survey quality land description, I probably can't wiggle out of mapping it. I probably need to map that document, okay? Now, when I say a land description, that doesn't mean an address, that doesn't mean a tax assessor parcel number, that doesn't mean a napkin sketch. That means an actual legal description like you would find in a deed. I don't believe surveyors are required to map documents that refer to an APN or an address or a napkin sketch. Okay, now they may put some notes on the survey about that. They may even decide to map it, but I don't think you can demand that they do that per the spec. So that's the first key question when you're trying to decide if a surveyor should have mapped an exception is, does it have a survey grade legal description? Okay, the second thing is, does it define an area that can be physically located on the ground? So you may think, well, those are the same things. Excuse me, my allergies are bothering me a little bit today. They're not the same thing. So let me give you an example of an area that could be mapped on the ground that might not have a survey grade land description. So in one of the counties I work in Central California, they have a policy of anytime you go in to do development, they are going to take an easement over what they call the riparian habitat corridor. And essentially, if you read the county ordinance, what it says is they aren't going to let you build within so many feet, I think it's 50 feet or 100 feet, let's say it's 50 feet. They won't let you build within 50 feet of either the top of bank of a creek or stream or 50 feet from the edge of the riparian woodland, whichever is greater. Okay, so whichever pushes that line out the farthest. Now, there is no land description for that, right? That's a county policy, it's a county ordinance, and that language I gave you, 50 feet from the top of bank or the edge of the riparian woodland, that's what controls. Now, in many cases, I can determine where that's at, right? Via topography survey. If you've worked in my area long enough, you know what a riparian woodland looks like. If there was some controversy over that, you could hire a biologist. We have a good biologist we work with, but I can probably plot that line on my survey, and I probably should. That's something that the lender and the title insurance company are going to want to know. So there's an example of an encumbrance on a property that may define an area but not have a survey legal description. Okay, may not have a legal description in the technical sense, like an easement deed. Okay, another example is if you have an easement that's shown on a survey map. So there's an easement dedicated on a map that may not have a separate land description, and I'll try and remember to put a link to my video that talks about that. But it's still an area that can be mapped, and I can plot it on my land title survey, so I should do that. Okay, so what about all that stuff that's not all those exceptions that aren't survey matters? What should your surveyor do with that? Now I know some surveyors that just don't show them at all. Some surveyors will list them. And what I try and do to help my clients here at Redefined Horizons is I always list those non-survey matters, and I try and group them into categories so that the person reviewing the land title survey can get an idea of what exactly those exceptions are. Because when a surveyor lists an exception, so let's say exception 7, and he just says not a survey matter, he's not adding a lot of value there, is he? Or she? She's not adding a lot of value. I think you could do a lot more as a land surveyor to help your client. So what we do on our land title survey is we will group those exceptions on our list on the face of the map, and we'll group them into a few different categories. And that just helps the reader understand, hey, Landon told me he couldn't map this, it's not a survey matter, but is it something I want to go take a closer look at? And so that's what we try and do. And we also try to recommend to our client, if there's non-survey exceptions in the title policy, land title policy, that we think they need to look at. So hey, this isn't a survey matter, but we think it affects title, or it may affect the location of a boundary line, and you should really go take a look at it. And maybe they need us to take a look at it. Maybe they need us to get a title professional to come in, or an attorney to come in and render an opinion. So we always try and, if there's a yellow flag or a red flag that needs to be raised, we try and do that, even if it's not technically a survey matter, because that's how we provide value to our client. So, what are some types of kind of broad categories of non-survey matters, non-survey exceptions that we use when we do land title surveys here at Redefined Horizons? I'm going to give you 6, okay? And there could be more, but these are the 6 things that that commonly come up. So, we group exceptions related to financial instruments. We will group those. So we'll say exceptions, 8 through 12 are financial matters. They are not survey matters, and we'll list them. So that includes deeds of trust, loan documents, foreclosure documents, mechanic liens, that kind of thing. So that's the first category. Second category is all kinds of legal notices. If there's a lis pendens or some other type of legal notice about the property, sometimes you find legal notices about toxic waste or about environmentally sensitive habitat, whatever. If there's legal notices about that, we will group those together. That's the second group. Third is land planning restrictions. So a lot of times in the title report it'll tell you, hey, this property is part of this, it's part of this special district, or it's part of this specific plan, or it was part of this development agreement that imposed certain land use restrictions. We'll group those together. That's the third. Fourth is payment of taxes. There's usually all kinds of exceptions for taxes in a title insurance policy. Special assessments, the general taxes, taxes that are overdue, taxes that are due currently, taxes that will be due in the future. We try and group those all into a category for our clients. So that's the fourth group is taxes. Then we have the fifth group, which is what we call boilerplate exceptions. So title companies will frequently put boilerplate exceptions in their title policies. They go in every title policy. They're not specific, they're just generic. So they include exceptions for things like water rights, parties in possession, rights of the public to roads. So we group all those boilerplate exceptions together, and those are frequently the exceptions that we recommend our clients get removed from the policy. So if they're not applicable, then we recommend that the client talk to the title company about removing those, and oftentimes the title company will. That's part of how we provide value to our client. So I'm not saying it's never appropriate for those kind of boilerplate exceptions to be in a title policy, but oftentimes they're not needed. And really, the title company, if they're putting an exception into title policy, it should be because they've done some specific research about the property. As a general rule, if you're the lender or the buyer, you don't want your title company just throwing a bunch of boilerplate exceptions in your policy. So that's why we group those together. That's category number 5. And then finally, the 6th category is there's oftentimes exceptions about escrow or recording. Right now the title companies are including some language about COVID-19 lockdowns and how that might affect closing and escrow or recording, and so we'll group those exceptions together. So if you've got a good land surveyor and a good private land planner, he's not just going to take the easy route out, or she isn't going to just take the easy route out and say exception 8, not a survey matter. She's going to try and give you a little more information. She's going to try and work with you as the client to understand, why is that exception in the policy? Is it appropriate to be in the policy? Should it be removed? Is it something you need to talk to the title company about? So What's the point? Work with a good land surveyor. Don't get your land title survey based on low bid. Work with a surveyor who's going to carefully examine the exceptions to that title policy, title insurance policy, and is going to help you understand them, and is going to do more than just tell you, this isn't a survey matter, this isn't my problem, right? You want to work with a good surveyor who's going to help you understand exactly what kind of title insurance coverage you're going to get for your purchase.